Good afternoon to our audience. I would like to warmly welcome you to this event at the British Institute of International and Comparative Law. We have, during the past few years, discussed in various ways the consequences of Brexit and the new relationship between the United Kingdom and the EU after Brexit. But one topic has not yet been the center of the debate, and this is the new relationship between the UK and another country, which is in a rather similar position. It is outside the EU, but has close links with the bloc, and this is Switzerland. So the bilateral relationship between the UK and Switzerland is the topic of today's event. And we will hear first a keynote speech given by His Excellency Alexandre Fasel, Ambassador of Switzerland to the United Kingdom. And then we will be looking at two particular topics of this new relationship, which are the area of financial services and the area of innovation. So it is my great pleasure to welcome His Excellency Alexandre Fasel, the Ambassador of Switzerland to the United Kingdom, to this event. He will give us some insights on this new relationship in his keynote speech. Thank you so much for being with us today, and the floor is yours.
Thank you very much, Professor, and thank you very much for the invitation. And can I commend you for this initiative to bring legal experts and embassy people together to dwell into the rather technical details of our relationship with the British after Brexit. So I'm very happy to be with you and to have two of my lead experts on the matters we are going to discuss with me today. What I would like to do in my introductory statement is to give you the context, on the bilateral relationship between Switzerland and the UK with Brexit and after Brexit. So it would be about our reading of what Brexit is, what our perception of Brexit is, how we did react to it, where the topics you are going to discuss later on do fit in, and so that this is out of the way, and then you can really focus on the substance and the technicalities on the two panels you're going to have. So Brexit. And my remarks here will be of a political nature. So I'm trying to give you a political observation and appraisal of Brexit, not a legal one. And that is because I believe that political systems condition political realities, which then in turn drive and condition the law you are, as legal experts, faced with now. I mean, there is a legal reason why the law is the law you are now studying and faced with in terms of Brexit. So what is Brexit if we approach it from this political angle? My first point, and there I will have 4 points in that section. My first point is Brexit is the unsuccessful attempt to reconcile the representative and the plebiscitarian element and aspect of democracy. You remember Prime Minister Cameron wanted to derive from his policy, for which he had a mandate through the election. So from a representative mandate, he wanted to derive a plebiscitarian confirmation of what he was doing. And he failed. And Theresa May wanted to derive from the plebiscitarian result on Brexit in June 16. She then wanted to derive a solid mandate for her representative action, and she failed. So it was the unsuccessful attempt to bring together those two elements. My second point is it failed because the country was deeply, deeply divided, and divided not along the traditional fault lines between Labour and Tory, between left and right, but according a new fault line between leave and remain, which had created a new political identity in the country, but who cut through all received categorizations of polity bodies. It cut through parties, regions, industry bodies, families, couples. So a deeply, deeply divided country. And then that's my third point. How does the Westminster system, with the first past the post-electoral system you all know, how does the Westminster system deal with a situation where the country is deeply divided and not along the traditional building blocks of the polity? And the answer is it can't. So what does the system do then? And that's my fourth point. It does two things in a succession. First, it creates a hung parliament, which reflects the deep divisions in the countries. So if you want to translate the state of affairs of a country into a representation in the parliament, you don't manage, you end up with a hung parliament. And that's what the system did by returning no solid majority for Mrs. May in the election she had called. And that hung parliament did produce some convergence, albeit in a very, very strange way, by agreeing on what they would not agree on, but by being unable to produce an agreement on what it should be. So you remember at a certain stage, they resorted to an innovative tool in the House of Commons of indicative votes, where they put to an indicative vote what kind of Brexit could be chosen. A rather hard one, you know, with single market, without, with custom union, without, and so on. You remember at that one stage, after the second round of indicative votes, the Parliament had rejected 8 solutions, possible solutions, and the titles in the paper were no, 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 no. You remember that? But if I apply a Swiss logic coming from the Swiss democratic system, where everything is geared towards breaking power and sharing it, I felt that the indicative votes there, although not producing any positive result, by producing 8 negative results, had clearly indicated where the common landing ground was. And for me, it was clear, if the system wanted to find its way through, there it clearly was, and majorities could be fabricated around what Parliament had said. But when I tested that with members of Parliament, MPs and Lords alike, they wouldn't understand what I was saying because it was so alien to the Westminster system and to the ways and means of how British politics functions within the Westminster system. So the system goes into hung parliament and tries to muddle its way through, but isn't equipped to actually do it. And so the second thing it then does, it returns to the default position of the Westminster system, which is to provide a solid majority for the government of the day. And that's what happened when Boris Johnson called an election and he returned with a 80-strong majority to Westminster. And from then on, everything was clear and he could do how he wished and had promised in his manifesto, get Brexit done. So what we end up with in the end, because the system went back to its default position of being concerned with providing solid majorities that can solidly govern, rather than to produce an accurate representation of the people. I mean, you can hear in that system. Let's take now the current situation with the Conservative government. They have approximately 41% of the vote nationally, and they have une majorité écrasante in the Commons. That's due to the first past the post system. So the system is not concerned with representation, it is concerned with solid majority. And once you have that, and you have come back to this default position, then the government of the day produces the shots, calls the shots, and what that has produced is the hardest possible Brexit, bar a no-deal Brexit. And what we have now, the TCA, is harder than what the hardest Brexiteers envisaged and argued for in the campaign. And so the result is that for lawyers, you are dispensed of dealing with the legal problems that come with alignment, common rule book, harmonization, role of the Commission in supervising, role of the Court of Justice of the European Union. All those problems are gone and you are in traditional treaty law. But you're faced with a situation that creates a lot of economic problems because you have taken yourself out of a market. And it creates, as we see in the Northern Irish situation, considerable problem of a rather political nature. But again, I believe that what we've lived through here is a Westminster speciality. I do not expect that in any other country on the continent, we would have seen that result, and certainly not in Switzerland. In Switzerland, as you know, we are having our very own Brexit moment now around the institutional framework agreement. And lately, the discourse has been rather on the harder side, you know, let's stop the negotiation and so on and so forth. But I expect and predict that the pendulum will swing back and the system works in a way that it needs to find the common ground in order to proceed. So I do not think our way forward in Switzerland will be what you now hear as a majority voice around the institution framework agreement currently. So that was my first big point. What is my reading of Brexit, and why has after the referendum, the situation evolved in such a way that the British ended with the hardest possible Brexit? Another question then, but that would be zooming out too much, I think, for tonight's discussion, would be the reasons why the referendum in the first place was accepted. There are reasons for that as well, but I will leave it aside for the moment. So faced with Brexit, and that's my second point, is what was Switzerland going to do? And that's what we call the Mind the Gap strategy and the Mind the Gap Plus strategy. So we started back in Bern, we started analyzing what Brexit was and what effect it would have on our bilateral relationship even before the vote in the referendum in June 16 happened. So first analysis and analysis work went into that in the spring of 16. And immediately after the vote, into what we call un groupe de travail interdépartemental, so a cross-ministry task force, analyzed and then devised a strategy how we would need to respond to it. And that strategy, the Mind the Gap strategy, was signed off by the Federal Council in October 16, at a time where in London they still hadn't, recovered from the popular verdict, and it was not quite clear what they were going to do. And from October 16, we've been in talks, then exploratory talks, and then proper negotiations together with the British side in order to implement the Mind the Gap strategy, which, that was our wording, they called it continuity dialogue. And the Mind the Gap strategy was to safeguard existing rights and obligations in the bilateral relationship between the UK and Switzerland as far as that could be achieved. And the second element was, and that's the Mind the Gap plus element, the second element was to see where it is appropriate, how we could extend existing mutual rights and obligations with the UK. So we realized that our extremely close relationship, and notably in economic terms, the relationship with the UK was based on, of course, Britain's membership in the EU and our very dense network of bilateral relationship with the EU. Once the UK left the EU, there was the risk of a legal void, hence gap, which needed to be minded, and we needed to replicate what we had through our agreements with the EU. We needed to replicate that into our bilateral relationship with the UK. And we realized that this was important because our economic, political, and especially economic relationship is hugely important. We have a huge footprint in each other's economies. And somehow we just hadn't realized that. It was just automatic. It was just, we took it for granted. Everything was smooth running because of the British participation or membership of the EU and our quasi-participation in the single market. So when you look at the figures, they are quite impressive. Switzerland is the UK's third largest non-EU trading partner. And we are the largest trading partner of the UK with pre-existing EU free trade agreements. So of all the 40 or 50 plus countries who have trading agreements with the EU, we are, I must say, by far the most important. And in absolute terms, we are the third largest non-EU trading partner of the UK after the United States and China. So we are considerably more important than Japan. We are twice as important as Australia, twice as important as Canada, more than twice as important as South Korea or Singapore, and so on and so forth. So il y a un ordre de grandeur to keep in mind when we talk about those relationship there. And hence, that's why we were pushing hard, and that's why the British side then realized that, yes, indeed, something had to be done in order to safeguard as good as possible, as well as possible, this legal arrangement. And as far as it was possible, we managed. So we were able to conclude 7 agreements that replicate what we have now in what we had in our bilateral relations through EU law and our bilateral agreements with the EU. So those 7 agreements are a trade agreement, which replicates in turn 8 agreements we have with the EU. That is the free trade agreement of 72, the mutual recognition agreement, the protocol on agricultural goods, the agreement on fighting fraud, the agreement on customs security and cooperation, then an agreement on general preferences for less developed countries, so the general preferences schemes there, the veterinary agreement, so that's for all the sanitary considerations, very important, and also the government procurement agreement. So all that was packed into the trade agreement. And the other agreements are on civil aviation, on road transport, on citizens' rights, making sure that all the Swiss and the British in the Swiss and the Swiss here who are residents in the country because they have made use of the free movement of people are safeguarded. So safeguarding the acquired rights, that was the name of the game in the citizens' rights agreement. We have an agreement in the financial field on non-life direct insurance. We have a police cooperation agreement because the British were going to not to be associated any longer with the Schengen database. So we do it on a bilateral way as well. And we have a service mobility agreement. So that grants access to individuals who are service providers so that they can continue to provide the services in either country. And we are still working on some leftover issues because we were not able to fully replicate what we had before. And the limitation to that was that we needed to wait and see what kind of bilateral relation the British would strike with the EU. Would they be as strongly integrated in the single market as we are? Hence, would they be, have a common rule book, as Mrs. May said, or alignment, as you could say? Would they go as far in the harmonization domain as we do, or not? And we found out through the TCA that they did not at all, and that there is no alignment in legal terms. So all the domains where we are fully aligned on EU law, we could not enter into mutual recognition agreements with the UK. We needed to wait how they would set up, and now we see that we cannot grant mutual recognition in all domains where we are aligned with the EU. But what we were able to do in the mutual recognition side is approximately 70% of the trade that could be replicated through MRAs, but many chapters of the MRAs could not be replicated. Another problem is on the rules of origin, because the British did not choose exactly the same wording and system of rule of origins in their relationship with the EU, and we needed exactly the same wording or exactly the same system so that we could triangulate. And for the rule of origin, that's especially the question of the extended cumulation of rules of origin, where we have a problem, but we are working on it together with the British. And I think we are going to find the trick and the way through it, and that should be okay. We are also working on a mutual recognition agreement for the authorized economic operators. So that's a question in the field of the customs, because when we saw in the TCA, the British did not go as far in their bilateral relationship with the EU as we do. So we needed this special element. So we are doing that currently. So that's for the mind the gap. And then the mind the gap plus there is a series of topics where we have already started work. One is we will, and that's our joint ambition, that we will need to update and modernize and expand the trade agreement. And discussions are about to start, scoping discussions of what exactly we could improve there. We have a memorandum of understanding in terms of migration, where we see the possibility of a fairly large conversation on migration, including on asylum and refugees. We are working on the problem of social security coordination, where we think that we will have a modern agreement probably this year, say in the fall. And one of the two topics today, financial services, mutual recognition in the field of financial services. There we create something entirely new, because we have no agreement on financial services which extends beyond the insurance agreement we have with the EU. So we are free to imagine a new system of mutual recognition of our rules and regulations in the domain of financial services, mutual recognition based on outcomes rather than the exact nature of legal texts. Alexandre will delve into that very ambitious approach we are trying to have together with the British later on. And then finally, the whole question of innovation, which is also going to be dealt with in a panel tonight. So, of course, that is in part, it has to do with Brexit, in part it hasn't. I mean, we always have very closely cooperated in terms of innovation and research with the British. What has changed now is that we are both third countries, and we need also to take into account that while the British have secured their participation in the Horizon Europe program, we are not quite that far. You remember there is this link between the institution framework agreement and our being able to negotiate our participation as an associated country in the Horizon Europe setup. So, but then there are a lot of elements we already do and want to intensify in the innovation field, want to intensify on a bilateral level, and Lutz Berg will be able to give you more insight and detail on that. So that concludes what I wanted to tell you in terms of context, what Brexit was. It could only happen as it did, I think, here, but it has happened. We needed to adapt. We succeeded, but of course there are limitations to it because of our sectorial participation in the single market. So not everything can be easily replicated, but yes, it opens new possibilities of engaging further, notably in the field of financial services and of innovation. And with that, I hand the floor back to you, Professor. Thank you very much.
Thank you so much for that fascinating talk, and it gives us hope that this cooperation will be very fruitful. I wondered if there are any questions. I haven't said it to the audience yet. You could put your questions in the Q&A section, so the ambassador kindly agreed to take some questions. The same for our speakers. So if the speakers would have a question, feel free to ask it directly. I mean, I have maybe a smaller question or a side question. I find it quite fascinating that there seem to be a lot of new opportunities for cooperation. And I also wondered there is also room for creativity here, as you mentioned, for the area of financial services. So do you think the UK and Switzerland could become forerunners in international treaty drafting as well, to some extent? They inspire even, treaties with the EU by creative solutions or treaties between other countries?
Yeah, not so much in the process of drafting, but in the content of what we will draft and of the agreement. So if we can pull it off, and Alex will explain in greater detail, that will be a real innovation to recognize each other's regulation based off what the regulation produces, and not of how the regulation is actually drafted and crafted. That would be a novelty, a global novelty. Nobody has attempted to do that. This is what we attempt to do. It's difficult enough, but we are properly convergent in terms of general outlook on the subject and philosophy. So we are very confident that we will pull it off, but it will be technically hugely complicated.
There is one question in the Q&A section. I don't know if you can see it. The question is from Diego Acosta. Would you envisage a bilateral agreement on free movement of people between Switzerland and the UK, like the EU-Swiss bilateral agreement?
So yes, we are organizing the bilateral migration rules between Switzerland and the UK. But from the moment that the UK leaves the EU, there is no free movement of people anymore between our bilateral relationship. And so both Switzerland and the UK then become third countries. And the starting points for any talks or negotiations are the respective national legislations as far as foreigners are concerned, Ausländergesetzgebung in either case. And so in their setup, the UK does not consider free movement of people with anybody. It's precisely what they wanted to get out of, and they have introduced this points-based system. And we have our very own legal system on foreigners, and the British are now third country nationals under that legislation. So the coordination or agreements we need to find is how best we can facilitate the movement of people between our two countries based on our legal orders. I do not think that neither the UK nor Switzerland is going to change its own legal order to accommodate the other side. So when your question is technically whether we will have free movement of people with the British as we have it with the EU, then I must say the answer is no. But we are trying to find solutions that allow a circulation of people which is as free as possible.
There's also two further questions. The next question is, could you expand on the status prospects of the EU-Swiss framework agreement, or will the bilaterals continue?
I don't even know whether I can expand. I can paraphrase what you have read and where the situation is. The basic situation is that yes, we want the bilateral agreements to continue. We think that the bilateral agreements, such as we have them and have developed this bilateral way since the rejection in a referendum of the European Economic Area, that this is the way to go for Switzerland. C'est pour nous la voie royale. So that's what we would like to expand, to safeguard and expand. Now, there is a condition. In the eyes of the EU, there is a condition to that. They say, yes, it's all very well, let's continue on that track, but we need a framework, an institutional framework agreement where we bring some governance into our relationship, and some need to clarify some of the questions that have been constant questions discussed in the joint committee without ever being solved since the bilateral package 1 and the bilateral package 2. So that agreement was negotiated, and a text was published in December by the Federal Council, and a conversation then started in Switzerland, which produced that we needed a series of clarifications in order to be able to sign the agreement, to submit it to Parliament, so that Parliament can then discuss and adopt, and probably then, or most certainly, there would be also a referendum on it. But so for those clarifications, we need further discussions with the EU, which for some time we did not start because we were faced with the BGI, the Begrenzungsinitiative. So we needed to overcome that challenge first. And then the Swiss side went back to Brussels to lead those discussions. And last Friday, the president of the Confederation visited Brussels and saw, then explained that the positions were still very far apart, and that if nothing was going to happen, then probably we would not be able to conclude. And now you are in a typical situation you find towards the end of negotiations when, when es ans Eingemachte geht, as we say, when the really tough questions come, then the parties engage in briefing wars, and that's exactly where we are now. But the fundamental position is, yes, we will not throw away our bilateral relationship. And there is this fundamental difference between Switzerland and Brexit. If the institutional framework agreement doesn't go through, then the two bilateral package and all the others, 120 plus agreements, they're still there. It's just that we are not able to further expand the relationship with additional agreements or our continued participation in EU programs. Whereas the British, by leaving, they were leaving. If they didn't conclude a TCA, there was going to be exactly nothing. And now they have the TCA, which is admittedly a very modest sort of agreement compared to the Swiss setup.
And if you may allow, there is one last question by Margarita Salvadori. If you can see it, she would like some clarification on the application of the mutual recognition principle.
Would you please read that?
Don't know if
the mutual, which I'm unsure which mutual recognition principle you are referring to. We were in our mutual recognition agreement with the EU, there are 20 chapters. And of those 20 chapters, we were able to replicate 3. because those were chapters where the rules are based on international standards rather than EU law. So we were able to grant mutual recognition because the rules and standards come from international law. In the 17 other chapters, the rules we need to recognize are based on EU law and our alignment onto EU law. So we cannot, as Switzerland, recognize as being equivalent British rules when the British say, and that was the whole point of Brexit, that they want to have the possibility to diverge. So we cannot recognize rules of which we don't know whether they will diverge down the line. And we cannot recognize rules which are not ours, but are rules we've taken over from somebody else, which is the EU. So that was the limitation we had. Amongst those 17 chapters that are still open, in 4 chapters, I think we can find, we can muddle through, and we have some wiggling rooms to improve and facilitate the movement of goods around it. And in the 13th left, we are just solidly with the single market there, and mutual recognition agreements will not be applicable. That does not mean that trade is not possible. What it means is that you are not able to certify yourself that your good that you are going to export is compliant with the rules of the other party. So we will have to, those certification be made in the European Union, in Britain, or vice versa. And that then means it's a question of cost. It's a question of cost, which then hampers economic exchange.
Thank you very much. Thank you very much for a very interesting and very enthusiastic speech, and for having taken the time to be with us today. I will now hand over